Welcome back. Glad to have you with us. Glad to be with you. It is the Gary Nolan Show. Hope you're enjoying your holiday, and I hope that you've taken the time to record today's program. We are pleased to tell you that Roger Pilon is with us. He is the founder and director of the Cato Institute's Center for Constitutional Studies. Now, I always read that. I always tell you about that. There is so much more to Roger that it would just take up so much time. But you trust me, he has written for the Wall Street Journal, the New York Times. He's been on national television. He's done work at the Stanford's Hoover Institute. He's got it down pat when it comes to the Constitution. In the segment before news, we were talking about the Supreme Court and 1937 in our review of the Constitution, and you were about to tell us, Roger, about some major changes.
Yes. Here, and I'm going to have to get a little technical, Gary, but just bear with me. During those first 4 years of the Roosevelt administration, as I said before the break, there were a number of programs that Roosevelt introduced that the court found to be unconstitutional because largely there was no authority under the Constitution to enact these programs. Don't forget, we're talking about a constitution of limited powers that are enumerated in the document. And the court didn't do a perfect job of it during those early decades. It went back and forth. But by and large, it held the ground and it upheld the Constitution. But after those first 4 years, in the landslide election of 1936, when all but two states went for Roosevelt, those two, interestingly, were Maine and, dare I say, my birth state of Vermont, which was a rib-rock Republican state back in 36, but today is, of course, the People's Republic of Vermont. In any event, I digress. In 37, after that landslide election, Roosevelt unveiled his infamous court-packing threat, his threat to pack the court with 6 new members so that he could have it come down on his side of things. Well, there was an uproar in the country over that. Not even Congress would go along with it, Congress that was in the House 4-1 Democrat. And so he backed off that. But the court got the message, and it began rewriting the Constitution without benefit of constitutional amendment, which is the right way to do it. And it did it in 3 main steps, 2 of them, one in 1937, one in 38, and another in 1943. In 1937, it eviscerated the very centerpiece of the Constitution, the doctrine of enumerated powers. And it did this by looking at 2 clauses, the General Welfare Clause and the Commerce Clause. The General Welfare Clause was written, as I said in earlier segments of this series, as a way that Congress could tax and spend for the general welfare, which Madison, Jefferson, and virtually everybody else defined as informed by the enumerated powers or ends that were listed further in Article 1, Section 8. What the court said in 1937 was that Congress had the power to tax and spend for anything that served the general welfare. In other words, they came down on the Hamiltonian side of that great debate between Hamilton and all the others, which said that there's an independent power to tax and spend for the general welfare, which means, therefore, that there is no real restraint on its power to tax and spend, since money can be used to accomplish anything. Well, that was the opening of the floodgates for the taxing and spending power under the General Welfare Clause. Then in the Commerce Clause, in a case called NLRB v. Jones and Laughlin, the court addressed the Commerce Clause, which had up to that point been understood largely as enabling Congress to check states if they interfered with free interstate commerce, and to do the few other things that pertain to ensuring free commerce among the states. Well, in Jones and Laughlin, the court came down to saying that it authorized Congress to regulate anything that affected interstate commerce. Well, there's nothing that does not, at some level, affect interstate commerce. Indeed, it got to the point in 1942 in the famous Wickard v. Filburn case, whereby the Agricultural Adjustment Act, which limited the amount of wheat that farmers could grow, was under challenge. Farmer Filburn had grown wheat in excess of the amount allowed under the Agricultural Adjustment Act, and so he was charged with that. The wheat never left his farm. It was wheat that he consumed in his kitchen and in his barn. But under the power of Congress to regulate interstate commerce, the court upheld the restriction on him and the sanctions on him.
So the argument would be, in the aggregate, if he's growing his own, he's not buying from somebody else, ergo...
There's the argument that they use. You've got it exactly right, Gary. They say his may not be in much of effect, but in the aggregate, then this is wheat that would not be bought on the market. I mean, it was a futile attempt to keep the price of wheat at $1.16 a barrel. I mean, a bushel. When on the international market, it was going for 40 cents a bushel. This was the kind of economics that the New Dealers engaged in. And then so therefore now the floodgates were open for Congress for both the redistributive state under the General Welfare Clause and the regulatory state under the Commerce Clause. But what happened now next is perhaps even more interesting. In 1938, in a case called Caroline Products, the court, in famous footnote 4, distinguished two kinds of rights, fundamental rights and non-fundamental rights. If a law implicated fundamental rights, the court would have to apply what's called strict scrutiny. In other words, the government would have to have a compelling reason for the law, and the means would have to be narrowly tailored. Here we're talking about rights like speech, voting, and later on certain personal rights. By contrast, if a law implicated non-fundamental rights like property, contract, the rights we exercise in ordinary commercial relationships, our economic liberties, in other words, why then the court would apply the so-called rational basis test, which is to say, if there was some reason, some conceivable reason that the legislature had in passing this statute, then it was good enough for the court. So essentially, and this, remember, now applied to both the federal actions and state actions, you could no longer invoke your non-fundamental rights against these actions. So essentially, we emerge with 2 1/4 branches of government. But what happened as a result of these changes in 1937 and 38 was that the legislatures, federal, state, and local, started issuing more and more regulations and programs, but they couldn't manage all those. So they started delegating their legislative powers to the executive branch agencies, the kind of agencies we have. We have over 320 here in Washington today. The Federal Trade Commission, the Federal Election Commission, the National Labor Relations Board. You can go on with all the F and N kinds of agencies that we've got.
So, Roger, if I may interject here, so this means that instead of Congress writing all the laws, they create a group and they end up writing their own laws. Is that where we're headed here?
Do we need any better example than Obamacare? They passed this massive 2,700-page bill, and then they say to HHS, to IHS, to Internal Revenue Service, to all the other agencies, now you go and write the regulations under it. And this is exactly what's happening today, and what has happened for the last 75 years. It is the jettisoning of the non-delegation doctrine that happened in 1943. And what that means is this. Remember what we said a few sessions ago. The very first sentence of Article 1, Section 1 reads, "All legislative power herein granted shall be vested in a Congress." It didn't say some. It said all. In other words, Congress, the body that we elect, that is responsible to us, the voters, is the body that writes the legislation. Well, what happened after the non-delegation doctrine is that the Congress delegated vast seas of executive power to the executive branch agencies. Indeed, just the end of June, on Tuesday, the last week in June, President Obama gave a address at Georgetown University about how he is going to change the environmental law to address global warming. He's going to do this entirely through executive order. This is power that has been given to him through the agencies by the Congress to exercise as he sees fit. In other words, Congress doesn't even have any say in it. And so there's where we've come, essentially through these three things. Again, let me just summarize it. We've opened the floodgates to the modern redistributive and regulatory state in 1937 with those two decisions I mentioned. We then bifurcated the Bill of Rights and created a bifurcated theory of judicial review, such that favored rights get strict scrutiny, unfavored rights get no scrutiny. And then finally, we've delegated legislative power to all these agencies, and that is the creation of the modern executive state.
So now I can say I care about the environment. I created the Environmental Protection Agency and take all the credit. But when the Environmental Protection Agency writes a rule that destroys your business, I can say, well, I had nothing to do with that. That was the EPA.
Absolutely. If it increases the corn-based ethanol from 10% to 15% and starts doing damage to your engines, and at the same time gives you lower gas mileage and raises the price of food, that's all done by the EPA. That's not done by Congress.
It's not fair. I'm the elected representative. I should be taking the credit and the blame. But if I can create the bureaucracy, let them write the rules, I can take the credit and let them take the blame. Say that I'm just unable to change it. If you just joined us, we were talking about the Constitution this morning, the entire program dedicated to it. Roger Pilon is our guest, founder and director of the Cato Institute's Center for Constitutional Studies, talking about the 1930s right now, where the biggest changes in the Constitution are. And we talked about how the interpretation has changed, but now we're going to talk about, in the next segment of the program, the things that directly led to, what it gave them permission to, in Washington, to create. Things that today many of us lament, many of us would like to get rid of, but we can't. And fundamentally, what we've done is, I believe, change the republic into a democracy, a very dangerous form of government. We'll come back and cover this ground right after this. Gary Nolan Show. It is the Zimmer Radio Network.